Hi, Omar. Good to see you. Omar, you're number 3 in the lineup.
And Marianne, we are good to get started. Thanks.
Thank you so much. Welcome, everybody, to our panel on international humanitarian law and crisis, issues in the context of the Israel-Gaza conflict. It's as Taylor Kilpatrick said, the 5th in a series of panels on current topics in international humanitarian law, sponsored by the American Society of Law's Lieber Society and co-sponsored by the DC Bar International Law Community. This series, begun in October 2023, the 4 earlier sessions are available on the ASIL website or on YouTube, aims to foster substantive civil discussion and debate on IHL topics and to educate practitioners and others about the principles of IHL. I'm Marianne McGrail. I'm on the executive committee of the Lieber Society. In the late 19th century, the Lieber Code was the first modern codification of both the customary international law and the law of war of Europe, and later was a basis for the Hague Convention of 1907, which restated and codified the practical particulars of U.S. military law for application to international war among the signatory countries. Lieber Society is named after that. I'll begin with brief introductions, introductory remarks from our expert panelists. First, we have Ido Rosenzweig, Professor of Counterterrorism, University of Haifa. Dr. Ido Rosenzweig is Director of Research at the Minerva Center for the Rule of Law under Extreme Conditions at the University of Haifa, and he's also a co-founder and chairperson of the Association for the Promotion of International Humanitarian Law. Just a quick note, could everybody who has questions, which we very much welcome, throw them into the Q&A function. Ido.
Thanks a lot, Marianne. I want to start with saying thanks to the organizers for this amazing series of sessions, especially to Britta, Taylor, and James for organizing and being the force behind the entire thing. I want to say that this series has by far been my favorite series of discussions on the current ongoing conflict in Gaza between Israel and Hamas, because the panelists that we have here and sometimes others that have joined us usually disagree on a lot of things, but we have still managed to do it in a very nice, polite, and civil way, and that's my favorite way to disagree with people. So I'm going to assume that this is going to continue today because there is no reason not to, and both the fact that you're going to disagree and the fact we're going to be nice about it. So when I was thinking about what are my opening words for this session, I remembered what I said, my last words in the last opening words in the previous session were kind of about the phenomena of sports fan approach to international law that we've seen over and over. And the more complicated things get on the legal aspect of this conflict, the more I get to see that approach or phenomena taking place. And I'm getting more and more concerned about the application of international law within that kind of environment. And when I'm talking about the sports fan approach to international law, saying that we've seen a lot of experts, which are by no means real experts. I mean, real experts in international law have the tendency to jump to conclusions that would fit with their preliminary understanding or thinking of the situation. And that applies to what we've seen in recent developments in the conflict, in the legal aspect, which is mainly the ICC, the Office of the Prosecutor, request to issue arrest warrants against the Israelis and Palestinians. We've seen that in the reading of the ICJ decision on the interim decisions on provisional measures in the South Africa versus Israel on the genocide convention case. And we've seen that in the reading and the immediate analysis of the recent advisory opinion decision by the ICJ. And that tendency to read things that weren't said into the text is very strange and very complicated, because we can see the same experts, and I'm not excluding myself from that phenomenon by any means, but we've seen those experts which are reading very carefully every word and every sentence in every other legal decision, trying to jump and quickly analyze current decisions into not what there not necessarily has been said in them. And that one aspect. The other aspect is the strong political reality influence on those legal proceedings. And I think one of the best example for me would be the decision to issue to request the arrest warrants by the Office of the Prosecutor in the ICC situation, because when we agree that from the perspective of the OTP, there is, from the prosecutor, he has jurisdiction over the matter, and I'm putting aside the question of the analysis of whether or not the jurisdiction aside, I'm not going to get into that. I agree that from the perspective of the prosecutor, there is jurisdiction. And that decision of the prosecutor to request for arrest warrants is a little bit worrying to me, because I know on the one hand, the prosecutor is basically almost forced to go forward in this case, because otherwise, what is the purpose of the court if everyone is talking about that conflict? Everyone is talking about violations and that takes place allegedly or actually taking place during that conflict, and the prosecutor won't do anything. Then that would definitely raise the question of what is the purpose of the court if the prosecutor is not doing anything, and not doing anything immediately under the international and public pressure that exists. At the same time, my reading of the situation is that those arrest warrants, whether or not they may be issued, will not be implemented, never. They will never be implemented by either side. Israel will not submit Prime Minister Netanyahu or the Minister of Defense Gallant into the ICC. They will never travel, if the arrest warrants are actually issued, they will never travel to a member state that will be forced to extradite them. And at the same time, the leader of Hamas, well, two out of the three, one might not be relevant anymore, will also not be and won't enter a member state. And if they are will be captured, I mean, if Israel capture them, Israel will prosecute them within Israel, and other states that have already put them on watch list and put arrest warrants against them will also want to prosecute them. So the chances are that they might be killed or prosecuted domestically are significantly higher than the fact that they will actually get to The Hague. So on both sides, we have arrest warrants, requests for arrest warrants that won't be implemented. So it seems that the entire purpose of requesting those arrest warrants is more symbolic than practical on that matter. And it worries me, because this is not what we're looking for when we are thinking about the ICC. The ICC is not meant to work and do symbolic gestures. It's meant to act when it can act. It meant to prosecute when actually there's going to be an actual outcome. And by the way, we can compare that to the situation in Afghanistan with regard to their request to, with regard to the US, where the pretrial chamber notified that well, there was no purpose with continuing with that because the US won't collaborate. So the notion of implementation was one of the reasons that the request of the OTP back then was declined. And I'm sure that Lila would correct me if I'm saying anything wrong about that aspect in that procedure. And it goes, that notion of political influence and the jumping to conclusion. I'm jumping to conclusions is a bit harsh, but I'm trying to be to speak freely here, is also applicable to the recent decision, the opinion, advisory opinion of the ICJ with regard to the settlements and the occupation. Because there's no doubt that I think unanimously or almost unanimously, 14-1 of the judges agreed that there's a lot of wrongful acts by Israel in the occupied territories. This is clear, but from that, and after reading all of the separate opinions and the joint separate opinions and the separate opinions, and basically, I don't think there haven't been a decision that was so split, and every judge wanted to say something additional to the main decision, sometimes jointly, sometimes separately. To jump to the headline, say that the occupation is illegal, when the majority opinion, the main opinion, did not say that those words, and they've done everything they can, whatever the reasons were, to avoid from saying the occupation is illegal. They said the presence is illegal, that Israel is conducting illegal aspect, that Israel should withdraw as quickly as possible. They've said a lot of these aspects and a lot of these notions, but they did not say per se that the occupation is illegal. Nevertheless, we've seen a lot of replies that says that, well, the court says the occupation is illegal, and that's it, that is the decision. And you also see that in the separate opinions or dissenting opinions, or I'm not sure how we refer to them in advisory opinion, where that they actually say, well, even if the court might have said that, this is wrong. So we've seen a lot of judges that actually went and addressed the question of the legality of occupation, and works explicitly said that this is not the question, putting aside the entire question of the status of the Gaza Strip, etc. So those notions and of the political influence and the sports fan approach to international law, which I'm either going to find a way to brand it nicely, or I'm going to keep calling it a sports fan approach to international law. I'm still working on that. Both of them are placing me in a place where I'm very much concerned about the influence of the current situation over the analysis of international law in the coming years, from different perspectives. And for the sake of time, and to hear others, I'm gonna stop here and give the floor back to you, Marianne.
Thank you very much, Ido. That was a great kickoff and very helpful. Our next speaker is Omar Najani, who's Carol Olson Professor of International Law and co-director of the Global Center for Business and Development at the McGeorge School of Law, University of the Pacific, also co-chair of the Land for All, an Israeli-Palestinian peace movement. Omar.
Thanks very much, Marianne. Are you able to hear me?
Yes.
Wonderful. Thanks so much to ASIL for organizing this panel and for allowing me to be a part of the conversation. And thanks as well to my co-panelists. It's wonderful to see all of you again. And like Ido, I look forward to a conversation that in the past has been both civil and rigorous. And like Ido, I'm sure that both of those things will continue today. I'd like to focus on three things in the opening remarks that we've allocated a little bit of time for. I'd like to start by taking up the topic that Ido addressed at the end, which is the International Court of Justice's advisory opinion. I'd like to then turn to some recent developments in the occupied territory that I think point to the urgency of action of the kind that the court highlights. And then finally turn to talking a little bit about some of the findings, factual findings with regard to Israel's conduct in the Gaza Strip and the imperative that those findings also raise with regard to action, both to bring an end to these hostilities and to provide for accountability. But let me turn back to the International Court of Justice's advisory opinion. I confess that unlike Ido, I see in this opinion a remarkably clear statement of what the law is and of what its implications are with respect to Israel's occupation in the West Bank and Gaza Strip. It is true that the court, in its words, emphasizes that Israel's continued presence in the occupied Palestinian territory is illegal, as opposed to characterizing an occupation as illegal. But to my mind, the distinction between these two concepts is not one that has legal significance that's obvious to me. What the court does in this opinion is, to my mind, quite remarkable, particularly insofar as what it's doing is building on a very significant foundation of work done since its advisory opinion regarding the legality of the wall in the occupied territory. What it does is not only characterize a range of particular policies and practices as unlawful, things like expropriation of Palestinian land for settlements and related infrastructure, the exploitation of natural resources by Israel when it had the obligation to preserve those resources for the benefit of the local population, the extension of Israeli laws to settlers and settlements. Not only did the court say, yes, each of these things represents a violation of core international legal norms, including, though not limited to, international humanitarian law, which continues to be one of the focuses of this panel. But it went beyond that to say that these policies and practices reflected an intention to exercise permanent control over the occupied territory, and thereby were tantamount to annexation. And the court went a step further in saying, by pursuing annexation in the occupied territory, Israel was violating two Jus Cogens norms. The first was the prohibition on the acquisition of territory by force. And the second was the norm of self-determination, the right of the Palestinian people to self-determination. And so what the court was doing here with remarkable clarity, I think, was to say that Israel's presence is unlawful because the way in which it is administering its occupation goes way beyond the regime of occupation and can only be understood insofar as it has attributes that reflect an intention to stay. And that is, to my mind, at the core of the court's achievement, and in some respects, an innovation insofar as it clarified questions regarding de facto annexation that were left a little bit ambiguous by its opinion on the legality of the wall in the occupied territory. So in addition to that, the court, of course, also pointed to the regime of discrimination that exists in the occupied territory, a regime that treats Palestinians who live within that space in fundamentally different ways than the Israeli settlers who do. And the court didn't shy away from looking at the structural dimensions of that regime. And although this is one arena where one might say there is a bit of ambiguity, the extent to which the court was labeling the regime that's in place apartheid or not, could be an area that we could talk about a little further. What the court didn't shy away from was declaring that the regime was in violation of one of the fundamental norms of the international system, the norm against discrimination. So to my mind, what we see in this opinion, and I really recommend that people read it. It's not super long, although, as Ido points out, there are many opinions by individual judges that add substantially to the page length. But I think that it represents a really important contribution to thinking about not only what the relevant norms are and how they apply, but also how the international community should respond. And the erga omnes character of some of the norms that are raised points to the imperative of an international response. I realize that my time is short, so I'll be quick with the remaining two things I wanted to say. The first is that I think that the ICJ's advisory opinion comes at a crucial time because, as Yahya Sinwar, an Israeli human rights lawyer, has recently laid out in an opinion piece in the Israeli daily Haaretz, and I really encourage you to look it up if it hasn't come across your desks already. He points out that there has been a very serious development in the West Bank, that the head of the Army's Central Command and the commander of Israeli forces in the West Bank signed an order that created a new position in what is called the Israeli Army Civil Administration. Not because the administration itself is civil, but because the military in the past has used this administration to administer the affairs of civilians in the occupied territory, in particular, including Palestinians. But in this order, a range of new powers are delegated to a new office, and that new office is answerable to only one person, and that is Israel's civilian minister of finance, Bezalel Smotrich. The reason it's important is that, as Svard points out, this is a step that takes us even closer to de jure annexation than anything that we have seen so far, that clearly posits sweeping powers, or at least the potential for sweeping powers to be exercised by Israel's civilian government in the occupied territory. And I think that this action points to the imperative of international action of the kind that the International Court of Justice suggests is necessary. The last thing I just want to raise, and then we can perhaps talk further about it later. In past conversations, this group has grappled with questions of intent as regards what Israeli forces have been doing in the occupied territory. And I would commend to listeners or viewers a letter that was sent to President Biden and has been covered widely, and I'll send all of these links to the group momentarily, by a range of volunteer medics from the United States who've worked for a range of NGOs and intergovernmental organizations on the ground in the Gaza Strip. And what they point to is not only the horrific scale of suffering that we see on the ground in terms of injuries and the scale of malnutrition that's unfolding exactly as was expected, predicted months ago when Israel was ordered to desist from its current policies, but also a very, very worrying phenomenon of young Palestinians, children being brought to medical facilities in the Gaza Strip with gunshots to their heads. And this pattern is something that these medics felt required particular attention because of the intention that they reflect. And as we muddle through what is, in some respects, an arena that is laden with difficult standards to apply, proportionality, for example. There are some intentional crimes that are not difficult to parse or to ascertain the legality of. And I think that the evidence is mounting of a growing body of those kinds of crimes. Thanks very much. I'm looking forward to the conversation.
Thank you, Omar. That was, again, a very powerful analysis. Our next speaker is Lieber Sadat, who is James Carr Professor of International Law at Washington University School of Law and was a special advisor on to the International Criminal Court from 2013 to 2023. We're very grateful for her expertise. Professor Sadat.
Thank you so much, Marianne. And let me join my co-panelists, Ido and Omar, both in thanking the Society for putting on this very, very important series of conversations about a true crisis in international law that is ongoing on the ground. And let me also thank Shiri and the others. I agree with Ido that we often disagree, but we do so cordially. And I think we all have at heart, in our hearts, I should say, a desire for a more peaceful and more secure world. We may disagree on particular aspects of the legal principles that apply, but I think we all have the same goal. And I think that's why we are so easily in conversation about these difficult issues. And it's with obviously a very heavy heart that we come to a fifth session on a conflict that we had hoped would have ended by now, and is still, alas, ongoing. I've been on vacation, on retreat, and I still can't get away from the updates on my phone that talk about another bombardment, another situation, another crisis. And so we are very much in an active theater of hostilities with ongoing fighting on both sides and a humanitarian crisis that was already catastrophic when the International Court of Justice ruled on it earlier this spring and has now sort of surpassed any understanding of what catastrophe means. I think Ido, I just want to say, I think Ido is correct that we struggle sometimes taking the language of the law, which can seem aseptic or sterile or complex, and translating it into something that the layperson can understand. And that's why I'm not sure that it's intentional distortion of the application of the law. I think, and I've had this conversation with many journalists saying, well, when you shortened it or made it understandable, you actually introduced a technical error. There is a problem because the law has to be understood. It has to be understood by the fighters on the ground. It has to be understood by civilians as what are my rights? What protection am I entitled to? And we have to sell it to politicians as these are the things that you actually can't do. They're off the table. They're illegal, as opposed to these are the things that are permissible. And so I do think we struggle with that, Ido. I think there is a tendency to blog too quickly. At the same time, we do have to get the message out as to what the courts are saying and how important the jurisprudence actually is. There is, as Omar said, a fierce urgency of now. There is ongoing conflict. Famine is creeping in. The Lancet just published a study that suggested, I think, 186,000 people would die in Gaza, not just from the direct casualties, but from the sort of consequences of the polio, wounds, lack of water, lack of shelter, dehydration, etc. And so this is a very urgent conflict that needs to be resolved imminently. One of the ways that the parties are, or that those interested in peace are trying to do this is through the application of international law. And that's why the International Court of Justice has been engaged not just in the advisory opinion, but obviously in the South Africa versus Israel genocide case, as well as at the International Criminal Court. I think what I'd like to say just in my opening remarks is one thing that has not been discussed in the blogosphere, but is painfully obvious to me as somebody having worked in this field for a very long time, is that the success of Ukraine's struggle to free itself from Russian occupation and the fighting that's ongoing in Russia and the annexation of territory in eastern Ukraine and Crimea, the fate of that conflict is tied to Israel-Gaza. And so when we think about the principles of international law that are going to apply with respect to the arrest warrants that have been applied for by Prosecutor Khan in the Gaza situation, they're the same crimes with respect to directing attacks against civilians and civilian objects that are being put out in the Ukraine situation. With respect to the annexation and occupation of territory, the same principles that the International Court of Justice elucidated in its recent advisory opinion will apply in Crimea, will apply in eastern Ukraine. And this is why I think the issue of double standards has loomed very large with respect to the situations in Israel-Palestine and the situations in Russia-Ukraine at the ICC. Now, at the ICC, when the arrest warrants were issued for Vladimir Putin and Maria Lvova-Belova, there was no objection by a Western state to the jurisdiction over the non-state party nationals. But when the arrest warrant application was put forward by Prosecutor Khan, I think completely appropriately, and I think Ido doesn't disagree with me, Prosecutor Khan has to do his job, regardless of what will happen. There was immediately an application by the United Kingdom that has now been withdrawn to challenge the jurisdiction of the ICC in that case. And I think my frustration with that, of course, states can do whatever they want, whether it's appropriate or not appropriate is another question, whether it's politically wise. But the fact that they couldn't see the direct linkage between the legal theory that is being used in the Ukraine situation and the legal theory that supports the prosecutor's arrest warrants in the Palestine situation is deeply problematic. And now, even though, as a colleague of mine said, the train has left the station and there are 70 applications to intervene of amicus in the ICC arrest warrant case, the conductor literally jumped off the train after completely derailing the ICC application. And I think we have to talk about that because international law can't have one set of standards for one party and a different set of standards for another party. Much of the law that is going to be necessary in order to successfully prosecute in Ukraine is undeveloped at the ICC. We have yet to have a case really at the court involving interstate bombardment, interstate attacks on civilian areas. And we have a lot of law, but it's from the ICTY. And the ICTY had a whole series of cases about siege warfare, bombing civilian areas, the siege of Sarajevo, the shelling of Zagreb, and all of those principles we would hope to be able to use in looking at the ICC case in Ukraine. They're also going to have to be used with respect to the arrest warrants in the Palestine situation. We have a lot of new law, the crimes against humanity cases in both the application for the arrest warrants in the ICC Palestine situation and the arrest warrants that have now been issued against the Russian military offers in the Ukraine situation. Very new charges, inhumane acts. They can't charge terror as a war crime, which was charged in the Galich case in Ukraine. So they're charging the campaign of Russia striking Ukraine in civilian areas as an inhumane campaign. I haven't seen that charge in the arrest warrant application yet for Prosecutor Khan in Palestine, but I think we will. And so I guess my point is that international law cannot be a pick and choose system. We are the lawyers. We do set aside a lot of the historical complexity. I know in some of the ICJ, we'll probably dig into that a little bit more. A couple of the judges were saying, well, we have to think more about the history. This is very complicated. As lawyers, that's basically not what we do. And I still remember when the ICTY prosecutors said every single time we go into, to prosecute a case, the defendants come back with a history lesson. They say, well, but this happened 100 years ago, or this battle happened this many times ago. And in fact, when we're applying the law contemporaneously in ongoing conflict situations, as happened at the ICTY, at the ICC and really is ongoing even at the ICJ. We have to apply the legal principles in an even-handed sort of very principled way. When I teach I'll just stop with this. When I teach international criminal law, or I teach international law, a lot of times to get students out of their heads in terms of which states are good and which states are bad and who are the good guys and the bad guys, I just give them letters, or I name them after, the Prozacs and the Zantacs, I use drugs or something, because then we can understand the legal principles. And I think what has happened in the particular situation in Palestine is that we get too sucked into historical narrative, and we, as lawyers, have to be very dispassionate about the legal principles. The prohibition against attacking civilians and civilian objects, the prohibition against starvation, the prohibition against annexation. These are uncomfortable perhaps to say when we know to whom they're being addressed, but the principles don't change when the parties change. And I think that would sort of be, it's the plea of law in this situation to sort of cut through some of the politics. And I give a lot of credit to the ICC prosecutor, who's also potentially facing US sanctions again, if this, depending on what happens in November, et cetera, et cetera. So I think that's where I would just start, is that we can't think of what's happening in Israel, Palestine in isolation. We have to look at it in the larger concept. And for all the people now trying to throw darts at the ICJ advisory opinion in terms of concluding, I agree with Omar. I think it said the occupation was illegal, even if not so many words, because it amounted to de facto annexation. To people throwing darts at that opinion, would you be saying the same thing if we were talking about Crimea? And so I think we have to be really careful. I think the court did an excellent job in that case. I think there is a lot to unpack with the separate opinions, and I hope that we'll have time to do that, Marianne, and thank you so much for the opportunity to be here.
Thank you very much for putting that all in context for us. A quick note before I introduce our last introductory speaker. The ICJ, link to the ICJ opinion and a bunch of links from the articles that Omar Bajani referenced are now in the chat function, and you're invited to submit questions through the Q&A. Shiri Krebs is the chair of the Lieber Society, which sponsors this program, and she is professor of law at Deakin University and co-lead of the Law and Policy theme at the Australian Government Cybersecurity Cooperative Research Centre. She's also an affiliated scholar at Stanford University Center for International Security and Cooperation, and she clerked for the Israeli Supreme Court. Shiri.
Thank you very much, Marianne, for this introduction. I would like to say it's good to be here with you because I, as everyone else, enjoy our conversations, but I also am quite sad to be having yet another installment of this series as the situation in Gaza is continuously deteriorating. So I thought first, I actually wanted to acknowledge that I'm joining this panel tonight from the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to their elders, past and present. It's 1 a.m. here in Melbourne, so I hope that I would still be able to make some sense and respond to the conversation as brightly as I would earlier in the day. So I wanted to start by kind of counting or placing down a few numbers, right? So as we mentioned, this is the 5th installment in this series. It's been 9 months as this current hostilities in the conflict have been going on. The count is currently at around 15,000 dead children in Gaza, and many, many more starved, injured, maimed, orphaned, homeless. also the same time of months where Israeli hostages are being kept in Gaza tunnels without any contact of the outside world or knowledge to their families about their condition, whether they're dead or alive. And so when I think about the legal intervention in this conflict, I, first and foremost think of the victims of this violence, the ongoing kind of violence and the ongoing victimhood that is occurring as we speak, which to me is excruciatingly frustrating that we're, kind of debating so many complex legal authorities without being able to actually do much good on the ground. And so I thought that my contribution to this perhaps somewhat discouraging conversation will be to think about three legal terms that have been particularly contested in the variety of legal opinions that we were planning to discuss today. And maybe I should also mention, we were planning to discuss the genocide case and then the ICC arrest warrants, but reality kind of progresses here faster than our installments in this series. So we always are kind of trying to catch up with too many issues to discuss. So the three legal concepts that I wanted to kind of raise are apartheid, genocide, and occupation. And I think they are all kind of present to some extent in all those recent decisions by the ICJ and the ICC that we were planning to discuss, and kind of stand in some of the most perhaps heated legal debates on how we term legally correctly what is happening currently in the conflict. And I think and so the word or the legal term genocide has been quite debated since the ICJ decision on this matter. But even though I think there are disagreements, sometimes quite severe even, or very deep disagreements on whether we can accurately describe what's currently happening in Gaza as genocide, it's probably harder to disagree on the number of casualties and the actual devastation that is going on. And so when we have hundreds of thousands of human beings starving, this is a case where I'm not sure that it really matters how we call it. We can agree that, that this is wrong. And we can agree, and I think even, in the ICJ decision and in other cases, we agree on a lot of things that we can call violations of this or that type. And so I think perhaps it's less important to agree on the particular legal term if we can agree that a particularly severe and egregious violation of is occurring. I think similarly, while the ICJ, so if we think about the two other terms that relate more closely to the recent decision, advisory opinion, so the ICJ didn't call the situation or the Israeli regime as apartheid, but did absolutely determine that it's a discriminatory regime. And so apartheid is a particular way to characterize this. It's a legal term that ultimately basically says we have a discriminatory legal regime that applies differently to different people based on who they are and particular categories of their national or racial belonging. And I think similarly with the idea of occupation, while as Ido mentioned, the ICJ did acknowledge that the occupation itself is not illegal, the ICJ did identify a variety of practices within the occupation that are in fact illegal, including de facto annexation, as Omar mentioned before. And I think that within that context, and I actually wanted to mention in this regard a decision that was made by the Israeli Knesset, the Israeli parliament, just a few days ago that didn't make a lot of noise, but I found quite overwhelming that a majority of 68 members of the Israeli parliament decided against only 9, made a declaration that there will never be any acknowledgement or recognition of a Palestinian state, basically kind of declaring that the entire area from the river to the sea shall remain under the Jewish state kind of sovereignty. And I was thinking about that decision in the broader context of how we define those legal terms of apartheid and occupation, because while the ICJ acknowledged that an occupation is not illegal on its own, there could be illegal practices. And I think we shouldn't really call it an occupation anymore because it's not what's going on. As the ICJ identified, it's a de facto annexation and annexation practices that are occurring alongside a variety of other discriminatory and practices. And so at this point, where we have this recent declaration from the Israeli parliament that there will never be a Palestinian state in those territories, what is the meaning of this occupation to begin with, beyond kind of just calling it or labeling it as such? And so I think regardless, and I've seen already a lot of kind of writing in our kind of in our international law community around kind of how to interpret the different parts of this decision about what it means with regard to the law of occupation. And I really do think that in this sense, what is happening are a variety of different practices that are far, far, far from the idea of occupation as it was envisioned when the law of occupation was written so many years ago. So I just wanted to put it out there and kind of think together perhaps in the discussion on how those legal terms, get a life of their own, and perhaps all we need to do is just release that sort of need to make those legal definitions and find our way to just determine what's wrong with what's happening. Thank you.
That's a big challenge. Thank you very much, Sherry. That's great introductory remarks. Reminder, there are resources in the chat, and please throw your Q&A questions into the Q&A function. Before we already have one question. Before we get to that, I wanted to just throw out the question of how does state sovereignty, how does the concept of sovereignty factor in to both the activities of the International Criminal Court? Of course, Israel is not a party to the Rome Statute, and the advisory opinions of the International Court of Justice. How does state sovereignty work here? I think we may have temporarily lost Omar, but I'm sure he'll be back. Would anybody like to take that up in any fashion? You can put any spin on it you like.
Well, Marianne, maybe I could take the ICC part, and then someone else might want to speak to the ICJ. And I do want to circle back eventually to some of the points that Sherry made, because I think they're very powerful as well. At the ICC, when it was established, the ideal establishment would have been to amend the United Nations Charter and make all states that are members of the United Nations parties to the statute of the court, which is how the ICJ works. But then the ICJ has this regime of secondary consent where states have to opt into consent, right? They have to opt into jurisdiction either through a treaty or some other method ex ante, or by special agreement ex post, or through the optional clause. And so I'll let somebody else take on the advisory opinion, where there was some argument that this violated, in a sense, Israel's sovereignty because it was a bilateral bilateral dispute, which the court rejected. And there's some very interesting things in the opinions about that. The ICC couldn't be established that way. It would have been too difficult to amend the charter, and there were significant debates about how the court would be constructed and what it would look like. And so it was done as a freestanding treaty, which follows the Nuremberg model, right? Because the Nuremberg model was also a treaty court, except that the ICC is a permanent institution. With 124 states parties, as well as an additional 5 under its jurisdiction right now, either through Security Council referrals or because they joined and then left, or Ukraine, for example, is under the ICC's jurisdiction, the ICC has become a widely recognized international court. It's not universal because several states, including states with large populations, haven't joined it. But the theory upon which the court's jurisdiction and functioning are established are the theory that the international community, that states can come together to create an international institution and endow that institution, confer upon that institution various powers and properties. And we see that both with the ICJ, with the European Court of Justice, with many, many international courts, the Law of the Sea Tribunal, and with the ICC. So states don't delegate. There's been this sort of weird theory about states delegating or transferring bits and pieces of their own criminal jurisdiction to the ICC. And that started really, I wrote a big article about this, and I call it Delegation Theory 1.0, which was the US arguments against the ICC at Rome. The US has abandoned those now. Then we had Delegation Theory 2.0, which sort of tried to preserve the autonomy of the ICC, but still have a carve out for immunity of heads of state who are not part of the ICC. And then there's Delegation Theory 3.0, which was basically this transfer theory. And that theory says if a state doesn't have criminal jurisdiction over a case, either because its national law deprives it of it, or because it's in a treaty relationship with some other state, then it can't transfer that jurisdiction to the ICC. I really tried to debunk that completely. I hope it was 25,000 words. I just think that's completely standing the way international law works on its heads. States can clearly come together to create an international court in some domain, assuming that court has all the indicators of legitimacy and authority that we expect. That is, if it's a criminal court, we expect the accused to have a fair trial. We expect the law to be well established. We accept the judges to be people of high moral standing who are removable for cause, right? We have certain indicators of legitimacy, and the ICC has all those indicators. And that's why I was so deeply frustrated with the UK sort of sovereigntist move to try to deprive the ICC of jurisdiction in the Palestine situation, only, by the way, over the Israeli accused, not over the Hamas accused. Because the theory was that the Oslo Accords took away from Palestine the right to try Israeli nationals, and therefore Palestine couldn't delegate that authority to the court. It was a too clever by half argument, because rather than attacking Palestinian statehood entirely, which was one possible avenue of approach, which had been used by other entities earlier, it attacked only the capacity of Palestine to confer authority on the ICC and to completely do so. I think we could argue, if you read Diri Tladi's separate opinion in the ICJ advisory opinion, we could ask whether that's even a legal restriction on Palestine. Does it violate Article 53 of the Vienna Convention because it impedes Palestinian self-determination, which the court has now said is a peremptory norm. But nonetheless, I just think the argument was just too clever, right? It's this weird transfer idea. And in the Ukraine situation, going back to my original report, it would mean that the ICC has no jurisdiction over crimes against humanity committed in Ukraine, because Ukraine has no national legislation on crimes against humanity. The court would literally have to look at the national system transferring authority to see what the extent of its own jurisdiction is, and that's simply not a plausible theory. So I think sovereignty, to me, it's not the Akhil Amar. Sovereignty means never having to say you're sorry, right? States are sovereign, meaning that they have rights and they have duties to the international community. They have the duty not to commit atrocity crimes and the duty to respect international law. So I think I'll stop there.
Thank you for that very helpful response. Would anybody else like to add to or comment on what's just been said on that question about sovereignty? Let's take Professor Sadat's suggestion and go to Shiri's suggestion that the language we're using is not adequate to talk about the issues we are confronting. So how do you respond to that? How does anybody respond to that?
Yeah, if I may, I think that this is a very dangerous approach to say that, well, this might not be a question of whether or not occupation is illegal or not. So let's talk about whether or not we are even talking about occupation anymore, which means, well, let's put aside the question of occupation and talk about, well, what Shiri refers to as the reality on the ground. But this is undermining the entire international humanitarian law applicable to the situation. If we look at the situation and we look at the advisory opinion, they talked about annexation limited to Area C. What about Area A and B? What about the Gaza Strip? There is still, even if we take that approach of, well, Area C is no longer occupied because it's annexed. Well, what about East Jerusalem? East Jerusalem, it's annexed, legally annexed by Israel. No one would doubt that Israel annexed East Jerusalem, de jure. No, I mean, de jure, de facto, whatever you want, Israel annexed East Jerusalem. So we're no longer talking about occupation there. I mean, that's a bit confusing. If we're not talking about occupation there, then, well, Israel's annexation of East Jerusalem is one problem, which cannot be addressed by any IHL situation. So IHL is no longer relevant to the entire Area C. And this is very dangerous because it removes a lot of the obligations over the Israeli authorities towards the civilians, the Palestinian civilians in the territory. I don't think that the settlements are by any means a good situation. And I don't think that we can have a discussion. I think the ICJ doesn't think we need to have a discussion about the applicable articles to each one. But the ICJ also didn't mention any of the security issues that Israel is facing in the occupied territories, and which allows and legitimizes some of the military operations that are being conducted by Israel. So I think that saying that the occupation is illegal and we no longer need to talk about occupation because we should talk only about annexation and its implication is mostly dangerous towards the civilian population. Keeping the notion that the situation is still mainly laws of occupation is the most important aspect that we need to maintain. And I will emphasize that the ICJ in its decision did not say that the occupation is illegal. And I think we need to distinguish between illegal acts of the occupying force and illegal occupation. Those are different terms. And the court really made significant hoops and cartwheels, legal cartwheels, in order to avoid saying illegal occupation, because they know, and I believe they know, I'm not one of them yet, that the situation is occupation because this is the applicable law. This is, if you look at the Hague regulations, if you look at the Geneva Conventions, this is the definition of occupation. And just to approach one of Leila's comments about the connection you see between the occupied Palestinian territories and the Russia-Ukraine situation, I think that we still have some differences in the situation. And as lawyers, we know we're looking at precedents, but we're looking on precedents in order to find the similar, but we're also looking to find the differences between two aspects. And I think that the reasoning that led to the occupation are completely different between the situations. And also, I think that, at least on paper, and I'm sure that we can have disagreement on that, Israel is still defined as a Western democracy. Russia is not defined as a Western democracy, which has some impacts on the rule of law in both states. And I will take that opportunity to also answer the Q&A question that was referred to me by Professor Marco Sassoli. I think that the prosecutor's decision to request for arrest warrants and the court's decision to issue those arrest warrants against Putin and what you asked specifically about Putin is on the same problematic and I would even say populistic approach by the prosecutor, because the court should focus on what it can do and what it's not, and not what it cannot do. And issuing arrest warrants that will not be implemented and reusing limited resources regard to situations that cannot be resolved through that mechanism is harming the effectiveness of the court, the reputation of the court, and it is, to some extent, a populistic approach by the prosecutor and even by the court, because they know that if they don't do it, as I said in my opening statement, the main question is, what are you good for? And they are very afraid from being faced with that question of Ukraine gave you jurisdiction, Palestine gave you jurisdiction. Now, if you don't act, what are you good for? And this is a political pressure put on the prosecutor, put on the court to move forward in a pointless attempt and procedure. And unfortunate as it might be, this is the reality. The court will not, Putin will not get to The Hague, and Sinwar won't get to The Hague, and Netanyahu won't get to The Hague. And imagining that requesting for arrest warrant or issuing arrest warrant against them will change that is, well, wishful thinking, but not reality thinking. I think that the entire process in the Gaza Strip, in the situation of Palestine and the situation of Ukraine, is a huge waste of resources by the court, which could have been used in a more productive manner. And I have much more to say, but I think I should stop at this point.
Thank you, Ido, and thank you for answering the audience questions. A reminder, please throw your questions in the Q&A. Omar.
Thanks very much, Marianne. If possible, I'd like to take up two of the threads that Ido spoke to, starting first with the point that Shiri was making earlier. I think that it's possible, on the one hand, to say that we've got to uphold our commitment to ensuring that the minimum level of protection of rights that international humanitarian law provides will be maintained. And I think that we can refer to Article 47, we can, of the Fourth Geneva Convention, which says that that changes by the occupying power and the legal regime will not deprive the population subject to its authority of their rights. We can say, hey, listen, in that spirit and in accordance with the broad mandate of humanitarian law, we are, to your point, Ido, going to ensure that the law of occupation's minimum protections are upheld. But I think that Shiri is saying, after 57 years, that minimum set of protections is plainly inadequate. And they're inadequate with regard to the protection of individuals' human rights, because IHL is simply inferior to human rights law in some respects. And I know there's been great work done looking at some of the risks associated with bringing human rights work into play in the occupied territory. I'm not looking to completely blow that off, but I think that IHL in a range of contexts offers a lesser array of protections, which is worrying in a situation of this duration. But moving from individual rights, I think that we have to recognize, and this is what I took to be the point Shiri was arguing for, and Shiri, correct me if I'm wrong, that what we are dealing with at core here is what the Declaration on Friendly Relations was very clear about, which is that when you're dealing with foreign occupation, particularly one of this duration, but even one that isn't, you're also simultaneously dealing with a denial of the right to self-determination. And when that denial of a people's right to govern themselves and all of the different ways that that means stretches on at such length, I think our discourse, we owe it to ourselves and to the people involved to ensure that our discourse is attentive to that broader problem. It's not just whether in particular right A or B is abridged. It's also whether we see this right that has been characterized as jus cogens, and which is even reflected in humanitarian law itself, in the prohibition on transferring civilians into occupied territory. When we're dealing with an occupation of this length, I think that we've got to refocus our attention on self-determination. And unfortunately, I think that using the language of occupation sometimes prevents us from getting at precisely that issue. The second point I would make is that I think maybe it's a two related point. I'm not sure that we can characterize Israel as a democracy at this juncture, particularly when we are talking about 57 years of occupation, when Israel has exercised control over the West Bank and Gaza Strip, where some 5 million people live without access to the institutions that decide every aspect of their lives. And that's been the case for decades. I think characterizing Israel as a democracy is a stretch, and that's not even reaching some of the dangerous trends that we've seen inside Israel, both in relation to the population as a whole, and particularly with regard to its Palestinian citizens since October 7th. But I think that kind of goes to the broader question that we were grappling with, which is when international institutions should act and when they shouldn't. And to my mind, the failures of enforcement that we see in play are features that should elicit more concern than the idea that the court is overreaching by trying to grapple with those failures of enforcement. I think it's right for this court, as Leila so beautifully put it earlier, to sort of act on the basis of its mandate and act equally in different circumstances. I think the greater the extent to which the court backs away from addressing what the entire international community is focused on, of recognizing a humanitarian crisis and the criminal acts that have given rise to it as something that is worthy of its attention. The greater the court does that, I think the more its legitimacy will be challenged rather than the inverse.
Thank you very much, Omar. I did want to bring in the Independent International Commission of Inquiry on the Occupied Palestinian Territory, which we did mention in our flyer. And so in the conclusions to their May 2024 report, they start off by saying 7th of October 2023 has marked a clear turning point for both Israelis and Palestinians and presents a watershed moment that can change the direction of this conflict with a real risk of further solidifying and expanding the occupation. That's how they started off. Do you think that report will have any impact on the conflict? Or that the commission's fact findings in which my understanding is Israel has not participated, will have any impact on the conflict? Sorry, Professor Sadat.
I'll come in with 1 minute and then my computer's threatening to restart, so I'll come back in. I think we've already seen it has an impact. It's quoted heavily in the ICJ advisory opinion. So I think the fact is that, and we saw this in South Africa's genocide case too, the International Court of Justice and the international legal community, the UN special rapporteurs, the United Nations system, this is the language of international law. And I think the Commission of Inquiry has had a tremendous impact. In fact, it was the Commission of Inquiry that really proposed that the advisory opinion be submitted, that the question go to the General Assembly, and it was on the basis of that Israel criticized the advisory opinion. Just one other note before my computer restarts is that a couple of judges did raise the point that Ido was making about Israeli security concerns, but Sarah Cleveland made the express point to say, you know, we invited Israel to participate. Of course, they didn't have to as a sovereign. It was their right, but we accorded them 6 times the amount of time that any other state got, equal to what Palestine got, in order to allow them to fully brief the court on their views and on the security concerns. And as a professor of international law, I can tell you states never do well in court when they don't show up and advocate for themselves. And so I think it's a bit unfair to criticize the court when the state that really had the information in its control refused to come and speak to the court. And I think it's to Israel's credit that so far it has been appearing in the genocide case that was brought by South Africa.
Thank you. Are there any other, oh, there she goes, she'll be back. Are there any other comments from other panelists? We have a few minutes before I'm going to ask people to offer their concluding remarks. And I'd also like, again, to invite any member of the audience to throw any kind of question into the Q&A, if you so choose.
So I just wanted to follow up on Professor Sadat's comments, just to say that, so I kind of my PhD, my doctorate, and a lot of my previous studies focused on UN fact-finding missions, and I recall this quote from Kissinger saying that establishing a fact-finding mission is an authority's kind of course of action when the desired outcome is inaction. And so just thinking about like the effects, right? So I do agree that, you know, some of the findings can then trickle down to other, so creating a body of knowledge. But at the same time, I think I've also found in some of my empirical work on fact-finding missions that too often, unfortunately, the creation of fact-finding reports generates or triggers the creation of opposing fact-finding reports, ultimately creating conflicting sets of facts that ended up, you know, as kind of intensifying conflicts rather than resolving them. And so unfortunately, I'm not particularly optimistic about how these types of intervention would, you know, play a role in the conflict. Not to say that this means we shouldn't do it. And I think in this case, I disagree with Ido on the point that international bodies should not kind of act if they don't have any sort of enforcement capacity, right? So I think, for example, saying that the ICC shouldn't issue an arrest warrant if it doesn't clear that they have a power to kind of fulfill it or to actually arrest. I mean, reality sometimes surprises us and we don't really know how things happen. With some of the previous arrest warrants, it wasn't clear at all that they could be fulfilled. And even in cases that they are not, they do make some actual effects in real life. For example, Putin can't travel to a lot of countries that perhaps he would have, right? And it would, be the same for Netanyahu, for example, if the arrest warrant should be issued. So I think just on this kind of point of what's the point in all this, and I say this as someone who's typically kind of the pessimistic voice on the panel. So just to say that I'm not optimistic on, the outcome, that immediately now we will have kind of agreement on the facts and that this would have an immediate effect on the ground. But I do think that creating this body of knowledge and collecting evidence is an important practice. And I do think that arrest warrants, even if they begin as a performative act, may also have implications that are broader than kind of an immediate arrest.
Thank you, Sherry. That was very helpful. Yeah.
Yeah, just a quick reply to the two comments by Sherry. One with regard to the implications of the arrest warrants, which mean Putin or Netanyahu or Gallant won't be able to travel. I don't think this is the role of the office of the prosecutor to create travel bans over people. This is the role of the Security Council. The role of the prosecutor is to ask for an arrest warrant in case where is a suspicion that, etc., and that there is actually reality, the interest of justice and all that are being taken into account are also an important aspect. I mean, if the ICC statute allows the prosecutor not to act in case where the interest of justice suggests that in this case he shouldn't, it means that there are external considerations to be taken into account in that request of arrest warrants and actually conducting the investigation. It means that there are external circumstances, there are external considerations that the prosecutor is taking, and I think that the chances of the implementation should be part of those considerations, and the prosecutor should not act when there is no actual plausible chance of implementation of the arrest warrants. And I definitely don't think that creating a travel ban or a blacklist for specific persons is one of the roles of the prosecutor in that case. With regard to the Commission of Inquiry,
can I just quickly, just before we move on to the next one, it's definitely not what I said or what I meant to say, that it is the role of the ICC prosecutor to create travel bans. It was just a comment that arrest warrants have implications beyond what we think, and ultimately saying that they may actually be fulfilled, right? If people do travel. And that happens actually, and so it happened in the past in cases that were not necessarily conceived as such. So this was just to say that clearly the role of the ICC is to prosecute in cases where there is enough evidence to suggest that crimes under the jurisdiction of the court were committed. And so we are in full agreement on that. I think our disagreement is with regard to how much the ICC prosecutor should consider, the possibility or impossibility of, its arrest warrant is fulfilled. And I will just go back perhaps to Professor Sassoli's question, that ultimately this means that, you oppose the arrest warrant against Putin, and probably almost any arrest warrant by the ICC, there would be very few cases where, it's very clear that the arrest warrants can be fulfilled. And so it's not even clear at the time sometimes what may be feasible in the future. And so just to say that our disagreement is not on the role of the ICC, but on whether at all or to what extent the prosecutor should have any kind of considerations around feasibility, which are completely external in my mind to the role of a prosecutor. So
Thank you very
continue.
much.
Sorry for the new.
No, that's okay. I'm going to let you both respond and offer your concluding remarks since we're now in the last 10 minutes. So everybody will have a couple of minutes. If you would like to go ahead, please.
Yeah, so you want me to conclude, to give my second comment and start to conclude?
If that's okay.
Yeah, that's okay. Just making sure that I get it.
That
right.
would be great.
So with regard to the Commission of Inquiry, and I'm definitely, a lot more than I do, Sherry, about the general notion of commissions of inquiry and then other investigation systems. But under different capacities that I've had in the last years, I've been following the Commission of Inquiry and other different aspects which are related to the Human Rights Council. And I don't think that it's new to anyone that Israel does not collaborate with the Human Rights Council on these kind of aspects of mainly the special procedures, such as special rapporteurs, and of course the Commission of Inquiry and previous fact-finding missions, etc. Since the famous Goldstone report, the Goldstone Committee, which Israel refused to collaborate with, and ever since then, Israel does not collaborate with any commission of inquiry, and especially not with the permanent commission of inquiry that we have now, because Israel perceived this commission of inquiry to be biased. And I'm not sure that it is wrong after reading the report and their previous reports. And I also know that when the UN establishes different kind of commissions of inquiry or fact-finding missions, or they have different names and different procedures for them, externally from the Human Rights Council, through the Secretary General, through the Security Council, etc., Israel has collaborated with them, which means that the Commission of Inquiry's report is based on partial information, because they could not visit the Gaza Strip, because Israel did not collaborate with them, etc. So their report has no substantial background to be referred to even. And that goes as well to the special procedures that Israel does not collaborate with. And I think that if the international community would have wanted an actual examination of the situation, especially following the most recent ICJ decision in the case of South Africa versus Israel, where the court says that Israel should collaborate with an international commission of inquiry or fact-finding mission, then there should have been a separate, independent, a more agreed upon system to examine the situation. And I hope, I don't know, that the current Israeli government is very not collaborative at all, but I think that there would be much bigger chances that they would be allowed to go into the Gaza Strip. They would be allowed to actually analyze the situation on the ground, and the outcome would have been hopefully more positive in the notion that we actually care about, and this is to resolve the situation on the ground and not play the blaming game of who's responsible for what, but actually to get to a resolution of the situation of the ground, a positive resolution of the situation of the ground towards the hostages, towards the Palestinian civilians, towards especially the children that Omar has mentioned, to make sure that we actually have a positive resolution. I don't think that we have that when we keep focusing and using the Human Rights Council bodies and situations. And lastly, and I'm going to end with that because as part of my concluding remark, I want to address one comment made by Omar. I think that on the notion that Israel is or not a democracy at this point. I think Israel is not the best example of a functioning democracy in these days, but the gap from saying that Israel has its problem as a democracy, which almost every democracy in this current age has, and I mean, you can see in the US the democracy, you can see the UK in the last couple of years democracy. I mean, you have a lot of examples of problematic or democracies that have their internal problems. To go from that to this is not a democracy because of the situation, external situation in the laws of occupation, which is problematic. I'm not saying it's not problematic, but to say that Israel is not a democracy anymore, I think this is a significant leap that we should be very careful from doing, because at this point, Israel is still functioning democracy. Hopefully it will remain a functioning democracy and actually regain its status as a full functioning democracy. But also, when we make this kind of accusation, I don't think accusation is too harsh of a word, but when you make these kind of comments, we have to take into account the backlash towards Israel within Israel, that at some point, if the Israeli government get pushed over and over and over for trying to maintain its democracy and values and the rule of law, it might reach the point where say, well, you're saying that this is not a democracy, then well, the hell with it, and go completely nuts, and we have the extremists who are on the side of the government right now become the leaders of the government, and I really don't want to be in that point, and I'm really afraid of that point. But so I don't think that we should silence our criticism on Israel, but I don't think that calling Israel a no democracy is the point where we are at this point. And I want to thank you again for this great panel, and I finished what I wanted to say.
Thank you very much, Ido, for those moving words. Omar, do you have some concluding remarks?
Sure. The first thing I wanted to say is that while I don't think that what we have been arguing for is the blame game, I do think that the role of law is in part to define what conduct falls outside of the parameters of the acceptable, and then to promote accountability for that conduct. And so if that's the blame game, then I think that that is our function. I think that there are a lot of, going back to the point that Layla made at the outset of her comments, the extraordinary fact that we are still talking about this and that it is still continuing all of these months later. We have to use every tool at our disposal to bring it to an end. And I think that that needs to include individual accountability for what is unfolding there. And it needs to include clearer definition of what the boundaries of acceptable conduct are by a range of legal and political actors than we have so far seen. And so I think this is right at the core of our function. As for whether Israel is a democracy or not, I will just come back to, I don't want to sort of beg the ontological question. I'll just come back to a core point, which I think really connects to the question Shiri raised earlier. There are 14 million people in Israel-Palestine. 5 million of those people lack access to the government that makes all of the decisions that are central to their lives. That situation, however one wants to characterize it, cannot be allowed to continue any longer. And it's one of the things that has contributed to the horrors of October 7th and the horrors of the 10 months that followed October 7th. And so we as lawyers can't shy away from addressing that fundamental fact head on. And I think that that's what we're trying to do here.
Thank you very much, Omar. Leila.
Thank you. And so much powerful has been said. And I really agree with Ido in that all of us, I think, have a lot of fear about what this means. It's very distressing to see a state that was sort of part of our family at the receiving end of arrest warrants, their leaders at the receiving end of arrest warrants. But I think as lawyers, we do have to bring our dispassionate analysis to the situation. And I'm reminded of Sharif Bassiouni used to say, we're sort of like the Lilliputians trying to tie down Gulliver, you know, with our little tiny threads. We have kind of the beast of impunity, the beast of lawlessness, and we're trying to bring every legal technique and tool at our disposal to bear to tie this down and to stop the commission of the atrocities on both sides with respect to the hostages and with respect to the individuals living in Gaza. We never did get to talk about the genocide case. And I just want to leave you with it's slightly depressing. I'm usually an optimist, but I've been rereading Raphael Lemkin's biography, which I commend to all of you. It's called Totally Unofficial. And I've been reading it because, as you know, we're trying to negotiate a new Crimes Against Humanity treaty. And I've been thinking a lot about what it took to get the Genocide Convention adopted and enacted. And of course, it took this one man who had fled Nazi-occupied Poland, who had fled across Europe, who fled across Russia, who fled across Japan, who ends up in the United States and then is trying to convince his American hosts that these terrible things are happening in Europe and they should help stop them. And he writes in his biography that the reason genocide is so easy to commit is because people don't want to believe it's happening until after it happens. And I do think that that is our task here, is that we have to unflinchingly look at what is actually happening now while there is still some time to do something about it. So I will just end there.
Thank you very much. Shiri.
I think I can't stop that. I think this should be our our ending for this session. Thank you so much, Leila, for these words.
I'd like to thank again the American Society of International Law, Britta, James, and Taylor for hosting this. This meeting has been recorded, will be posted on YouTube and on the ASIL website. And of course, thanks to the panelists for modeling a civil and substantive discussion on these very difficult topics. Thank you all.
Thank you.